Shan sends his apologies. Unfortunately for Shan, he suffers from an inner ear syndrome, and it makes flying impossible when he gets that. So he was struck down with short notice, and unfortunately for you, Shan can't be here, but he does send on his apologies. My name is Stuart Buglass. I have been with the company for 10 years now. Nair & Co. as a whole, in that 10 years, have established themselves as a leader in developing consultancy services over 50 countries. And in those 50 countries, we serve our clients across accountancy, tax, corporate governance, HR, and legal. My specific function is human capital, so that covers all of the normal human capital areas such as employee relations, compensation and benefits, etc. But for my sins, I also advise our clients on data privacy. And I make sure that they're compliant with regards to local compliance issues across EU, Asia, and Latin America, in addition to Canada itself. Not sure.
We're actually discussing a few technical difficulties back here with your slideshow. So
I'll go blind. Essentially, what I'm going to be doing is I'm going to be aiming to cover off about 6 core areas of data privacy. To begin with, I'm going to be highlighting the regulations of data privacy. Now, what I mean by regulations, most companies get a flavour for what confidential information is all about. You'll make sure that that information is confidential. You'll have internal processes. But to be honest, local compliance goes a lot further than just having internal processes to make sure that things are confidential. You've got an awful lot of data privacy regulations that you need to be aware of. So I'll cover off what those data privacy regulations are in each of the countries across the globe. In addition to that, and staying on legislation, I'll be looking at money laundering. Now, there's a conflict there, an internal conflict between disclosing to a regulator an issue with regards to financial impropriety or sensitive financial data where you think one of your consumers or one of your companies is doing something slightly wrong. That disclosure is usually whistleblowing without their consent, but when it comes to data privacy, consent is a key issue. So there's a conflict between the 2 areas of legislation there, and I'll touch upon that. After that, I'll actually look at some of the key areas which are creating difficulties for any company in actually being data privacy compliant. And I'll be touching upon cloud computing, which is quite a new area, outsourcing to service providers, social networking sites, and also employee blogs, all of which create difficulties for companies in maintaining compliance against data privacy regulations. So let's first look at data privacy regulations. And I think the best place to start is the EU Directive. It's basically the mother of all data privacy regulations. And certainly in Europe, when it comes to data privacy, everything flows from this EU Directive. So all local legislators will have their own domestic legislation that flows from the directive. There'll be some domestic quirks, but the fundamental principles are the same. Essentially, you need to look at the fact that every data subject has the right to be informed, and every data subject has the right to their consent to you using their data. So what is being informed? Well, being informed, they need to know why their data is required. They also need to know what data is required. And once it's with a receiver of data, what are you going to do with that data? Who's going to get their hands on that data? And where's the data going to end up? And I think that last point, where is the data going to end up, is quite critical to the EU legislation. EU legislation actually states specifically that the data can be processed and controlled within the EU, but once it's outside of the EU, therefore, you can't actually transfer data outside of the EU. The regulators are very specific on the fact that EU data needs to be controlled in the EU, and it can only be transferred to countries whereby the European Commission identifies that country as having the same levels of control. And so far, there's only 5 countries where the European Commission have identified that as being comparable to the EU. To get around that, the EU Commission has basically said, you can transfer data outside of the EU, regardless of the fact that the local country hasn't got the same levels of data protection, only if the individual consents, and only if you contract with the receiver of the data outside of the EU for them to also be liable under the EU directive. Now, as you can imagine, that creates quite a lot of administrative difficulties. Each of your receivers of data outside of the EU need to be contractually bound to the directive, and not many receivers of data are going to be committing to that. With regards to law and statutory implementation, you're probably thinking, well, how does anyone get to know? So you've got all of these data privacy controls, but to be honest, when it comes to compliance, how is anyone going to know that I'm non-compliant as an organisation? Well, to be fair to the data privacy regulations in the EU, they vest the actual responsibility and the legal rights in the data subject. So the data subject themselves can actually take you to court as a corporation for breach of their data privacy rights. Now, the data privacy rights, people are very aware of what those rights are, and you might be aware that Rupert Murdoch, certainly, he's been in the news recently with regards to the issues on phone hacking. Sony PlayStation, they've had issues with regards to financial data being made available through hacking, and you'll also be aware of WikiLeaks as well. So it's quite paramount that you need to protect data privacy because the data subjects themselves are fully aware of their rights. In addition to that, you'll find that the regulators are savvy to the fact that any data processor, they need to register that they are a data processor. So you have a profile with the data regulator themselves. So when it comes to enforcement, they know who you are. Now, the problems with cross-border data transfer, we'll touch upon that for a future slide in cloud computing. But I think if we actually look at Latin America, then we'll move on to Asia, and I'll look into Eastern Europe as well. We'll see that the EU directive isn't the only area of legislation that you need to be aware of. There's a lot of activity at the moment with legislators in each country across the globe trying to match what the EU directive does. So in Latin America itself, they actually stole a march on Europe because they had a fundamental constitutional right way prior to the EU directive. And that's a right which is referred to as habeas data. And it translates roughly as you should have the data. Now, how that's been implemented practically within the Latin American states is the fact that each data subject, they need to have access to the data, they need to be able to correct the data if it's wrong, and they need to have an objection if they feel the data shouldn't be actually retained. But what they're not looking at corporations and how they're maintaining the data and where the data ends up and whether it goes to third parties. However, that's not to say that the Latin American companies are failing to address those aspects. Argentina has been one of the first countries that have really gone to town on data privacy. And what they've done is they've basically matched what the EU directive is. And they're one of the countries whereby you can actually pass data from the EU to Argentina without contractually binding the receiver of the data. It's deemed to be comparable in light of data privacy. Mexico and Peru, they're two other countries that are basically following Argentina's lead. And in the last 12 months, they've implemented statutes as well. Now, if we move our focus across to Eastern Europe, you'll find that Eastern Europe have very robust items of legislation, very similar to the EU directive, but what they don't have is they don't have the infrastructure to actually enforce the legislation. So you find that their legislation is slightly toothless with regards to actually implementing it against any breach. Asia, again, they're lagging well behind the rest of the world with regards to data privacy regulations. What you tend to find in Asia, across most of the countries, is the fact that they've left the responsibility down to particular industries. So industries will have codes of practice. Those codes of practice will be voluntary. So at the end of the day, corporations aren't bound to data privacy regulations. Where they do have statute, you'll find that that's based upon the public sector or on areas of industry where it's sensitive data. So things like medical insurance, etc. A lot of those regulators will be focusing on their areas of the industry. So with regards to considering Asia, you'll find that in addition to these voluntary codes of practice, a number of the larger countries are actually focusing their attention on having specific areas of legislation similar to the EU directive. Now, China, they've implemented some recent legislation. Their legislation, though, is very much about the transfer of data outside of China. And I think one of the reasons for that is China are very aware that now they have developed intellectual property themselves. After spending a lot of time getting that intellectual property from the rest of the world, now they've got it, they don't really want that to be shared with anyone else. So they've spent an awful lot of time legislating against the transfer of data outside of China, and I think everyone needs to be mindful of that. However, the legislation is at draft form now. It's not enacted yet, so it's debatable as to how far-reaching that would be for private industry. With regards to India, India passed their legislation back in April, so that's fully enforceable. And they spent an awful lot of time on the consent of the individual. They want to make sure that the individual is aware of where the data is ending up. They want to make sure that the individual is aware of what it's being retained for and where it's going to be sent to outside of India. And they spent an awful lot of time not just on the consent, but on the opt-out, so withdrawing the consent. Now, if you consider yourself as a corporation dealing with Indian data, there's an awful lot of administration there with regards to opting in and opting out, and you're going to have to track that. Now, if you look at Canada itself, Canada has been focusing recently on anti-spamming. So anti-spamming is the regulating of unsolicited marketing. So you've all been there on your emails, or you've all received posts through, which is evidently unsolicited mail, unsolicited email from companies that are marketing for your business. Canada have been looking at anti-spam regulations whereby you need to opt into that. You'll only receive it if you've opted to actually receive that information. And likewise, similar to India, you've got the option of opting out. Now again, for an organisation, the administration behind opting in and opting out is going to be difficult for companies to actually administer. So we've spent an awful lot of time looking at the legislation and how it impacts on global business. Now, I think what we need to look at, in addition to the data privacy regulation, and I touched upon this at the start of the presentation, is the money laundering aspect of the legislators. Legislators in each country are very aware that when you're dealing with financial data, it may be that that financial data could be of a suspicious nature. So if it's consumer financial data or if it's corporations that you're dealing with and you've got any suspicions on that financial data and the activity that those individuals are dealing with, then what you need to do is you need to disclose that. And there's positive obligations through legislation on a company to disclose that to the regulator. In doing so, and in true whistleblowing form, the individual can't actually be made aware of that because the cat will be out the bag. Now, that's in direct conflict with data privacy. So with regards to data privacy, the whole concept is that the individual has data consent. So they should be aware of where their data is ending up. Now, some of the legislators in each country, they've basically had a look at this and thought, well, there's a conflict. So when it comes to the primacy of legislation, which of those pieces of legislation is deemed to be of primacy to the other? And most have taken the option that, yeah, it's money laundering. So where you've got an issue with financial data which you think is suspicious, then you've got that right to disclose it to the regulator, and you're not going to breach data privacy regulations in doing so. Now, some of the legislators haven't actually done that. They haven't actually discussed amongst themselves that there is a potential conflict. Now, what I would suggest to any organisation, when you've got a consumer contract or a commercial contract, you need to basically have a clause in there which allows for the consent of that data to a regulator from the money laundering perspective. Now, having looked at the regulatory framework, I think it's possibly a good idea to look at the areas that are going to cause you most risk with regards to compliance. Now, cloud computing is a particularly new area to a lot of businesses. What cloud computing means is there's a use of a third party, and they will provide networks, they'll provide servers and storage. Now, the key word here is third party. Now, for any organisation that wants to be compliant with data privacy, the fact that a third party is actually dealing with your data I might be able to actually get the slide up now. No? Ah. No? No. Ah. Too far. Here we go. Yeah, so cloud computing. You've basically got third parties dealing with your information. Now, as a third party, alarm bells ring for anyone who's looking after data and making sure that you're data privacy compliant in each of the countries you're dealing with. Now, the reason for that is, if you look at the legislation is drafted that the receiver of the data, the first port of call for that data, that individual or that corporation is called the controller. So you're responsible for that data. Now, if you pass that data to a third party, you're still responsible for the data. It doesn't matter that the controller's gone to that third party. A data subject can enforce the data privacy regulations against the person that initially received the data. Now, obviously, with cloud computing, you're dealing with a lot of these third parties that are overseas. I've already touched upon the fact that under the EU legislation, you can't actually transfer data outside of the EU unless you get the vendor to contractually commit to abiding by the data privacy legislations in Europe. So cloud computing presents an awful lot of difficulty to an organization. Now, if we think of cloud computing as a third-party service provider, we need to consider other service providers, not just from a data privacy standpoint, but also from a confidentiality standpoint. Now, your data may be financial data that you've held on your company. It might not be personal data, so some of the data privacy regulations might not apply. But where you've got data that you consider as confidential within your organization, and you're sending that to a service provider, you need to be aware of just how important confidentiality is to that service provider. Now, what we see is a lot of our clients will actually endeavor to assess through due diligence the ability of that service provider on the key task in hand, but they don't actually look at their ability to actually deal with confidential data internally and have processes that are robust enough to maintain it as confidential. Now, what you're all crying out for is you need some sort of industry standard whereby you can assess all of your service providers based upon a service standard for confidentiality. And unfortunately, the industry isn't helping you there because there isn't currently a standard specifically addressing this issue. Now, you may say, well, look, SAS 70 does an awful lot with regards to the internal controls of a service provider. It tells us exactly what's happening with regards to our data. It's telling us exactly what you're doing with the service that you're actually providing, but it doesn't specifically focus in its report on confidentiality. However, help is at hand because the AACPA has new guidance. And what that is going to do, it's going to actually introduce a standard for confidentiality. And I think that's what we're crying out for. So it's currently being developed. And I think the idea is that will be in place by the end of this year. So the idea would be, when you're dealing with your service providers, you need to think very clearly about not just their service for what you're contracting them for, but also for the confidential information that they hold for your organization. And I think once this standard is in place, I think it would be wise to actually ask them about that standard and make sure that they're adhering to the standard as well. Now, this leads us on to quite an emotive area, and that's social networking. Now, you're probably aware that a company can market to a far wider audience by using social networking sites. Social networking sites, they include Facebook, they include LinkedIn, they include Twitter, and as a company, you can obviously market. You can market to possibly a younger audience through Facebook than you would through newspapers or other forms of marketing. But what you need to be mindful of is who's actually operating your Facebook site as a corporation. Now, from my experience of Nair & Co internally, each department has their own ideas with regards to what is confidential information and what isn't. Now, if we say that the marketing department has control over the Facebook site, then you've got to ask questions as to whether they consider something confidential that, say, the finance department would, or possibly the operations department where there's intellectual property issues. So I think what's key to this is you need to have internal controls as to who's actually monitoring and who's actually controlling the data on Facebook sites. You make sure that it's aged, so it's never out of date. You make sure that all of your departments know what is actually in there, and you make sure that the marketing department, if they're responsible, they actually filter that data through to each department to assess its confidentiality. Now, beyond the company's own Facebook page, there's obviously a risk of personal social networking within the realm of work. Now, and it's not just with regards to the amount of resource time that employees are spending at the workplace social networking. It's the fact that the cyber hackers and the malware software engineers are basically focusing on social network sites. So if your employees are spending an awful lot of time at work on social networking sites, then essentially the risk is to your servers. If they're using your hardware, then essentially you're opening the risk to the malware being attached to your data in your servers. What's also interesting about social networking is the fact that professionals or scientists who use social networking in research and development are exchanging ideas all of the time through those sites. Now, ideas gleaned from a social networking site could be considered intellectual property by another company. And with that, obviously, they could be subject to copyright. So you've got to be careful. So your R&D guys or your professionals who are obviously those who are coming up with the ideas, where are they actually getting their ideas from? Can those ideas be traced back to another company? Because obviously there's an audit trail when you have these chat sites, twittering, social networking. So you've got to be careful of that. Another point that we often address with our clients is the fact that if directors are seen as a target for malicious gossip, then how many companies have extended your insurance coverage for D&O to cover the cost of mitigating and dealing with reputational damage? And what we see is not many companies have done that either. Another point on social networking, and it's a point that we've also touched upon, is Canada are obviously spending a lot of time on their anti-spam regulations. Now, a lot of countries already have anti-spam regulations whereby unsolicited marketing is something that needs to be opted in. You shouldn't be sending out unsolicited marketing campaigns to individuals who haven't opted in. So there's a positive requirement on the companies to ensure that you're only marketing to those individuals who have actually opted in to receive that data. Now, if you're on Facebook and an individual says that they're a fan of your company, by doing so, they introduce your company to their network. Now, in doing so, it's a grey area, but is that unsolicited marketing? Are you actually hitting individuals who haven't opted in? So I think with the prevalence of anti-spam legislation coming to the fore, I think Facebook is going to be a target for a lot of legislators. So have a clear policy with regards to social networking, your corporate sites, who's actually maintaining it. Have a clear policy with employees with regards to what they can do at work using your hardware. And I think it's also essential that you need to be aware that those in a position where they're gleaning ideas and generating intellectual property, that they need to be aware where are they getting their ideas from. Now, if we move on, employee blogs. So blogging is quite a new phenomenon. Essentially, individuals will vent their opinion within a forum. So it could be positive, it could be negative. The issue is that there's different types of blogging. So you can have employee-to-employee blogging, but very often you'll have employee to a wider audience blogging, and that's what you've got to be aware of. So what you need to ensure is, how do you control that? Now, a lot of the bigger organizations, such as Google, such as IBM, they've looked into this, and over the last couple of years, they've spent an awful lot of money trying to prohibit blogging. Now, the issue you've got with trying to prohibit blogging is you can't. It's one of those beasts that you just can't control. So far better than trying to prohibit the activity is to try and control it and try and shape it. Now, one of the reasons why you would want to shape blogging to make sure that it's not disastrous to your corporate PR is the fact that blog content rises with great speed to the top of search engine placements. So the fact is that blogs are updated so regularly and make reference to the company so repeatedly that they go very quickly to the top of a search engine placement. So if any of your consumers or if any of your potential network of suppliers, etc., wants a bit of information on your particular company, if they put that directly into a search engine, it's very often the blogs that will come up first. So you need to be aware of that. What a lot of companies have done, the large organizations that have already had their fingers burnt, is to embrace blogging. So what they need to do is they need to actually have a forum whereby they can control the content. Now, by controlling the content, they can actually have an internal policy. So IBM have spent an awful lot of time introducing a blog site on their intranet. And by doing so, they've actually engendered a situation where they want negative and positive feedback on that site. They know that if it's just positive and you're not allowed to put anything negative, that the survival of that site would last a couple of minutes. People would get bored of it and therefore they would blog elsewhere. They want to stop the non-company endorsed blogs. So in making sure that they've got an internal forum, they've managed to get rid of about 80% of their non-company endorsed blogging on the internet. And by doing so, they can also have an internal policy with regards to confidential information. And employees are quite happy to be able to blog and sound off about issues, and they're quite happy not to actually put confidential information on a blog, just as long as they've got that ability to sound off. So IBM are probably taking the lead on something I think most companies need to do. They need to have a blog site that's company controlled, where you can manage the confidentiality of the information supplied, but just let your employees have a moan. Now, employee blogs very often do target you as a corporation, but very often the blogs will actually seek out an individual. So it could be an employee or it could be a customer. Now, this leads us to a completely different area. So if a company or an employer finds out that there are derogatory comments about a fellow employee or a consumer, then essentially the company can be vicariously liable for any injury or any damages that that individual has actually had through those comments. So you need to be aware of that. And obviously, if I was an individual who had had comments made about me, I would probably go straight to the corporation rather than the individual who's making it, because it's a far easier claim. So I think we've looked at the legislation. We've looked at legislation both from data privacy and money laundering. We've also looked at some of the contentious and the newsworthy issues which are making compliance difficult. And we need to consider why compliance is important. Now, if you look at the issues with regards to enforcement, you'll find that it's not just civil liability. So any corporation could potentially have criminal liability as well for data privacy breaches. Now, what's the best country to illustrate this point is Russia. Now, in Russia, a company director of any corporation that's breached data privacy could actually be sent down for 12 months hard labor. So I think if you consider that as a potential penalty, then it's pretty important that you've got a data privacy part of your organization that's looking at these issues. Now, again, most of the organizations in each of these countries will have to be mindful of potential penalties. Now, the financial impact of those is pretty severe. Argentina, they've got penalties up to $100,000 US. Now, if we look at Europe, you'll find that all of the countries have pretty stringent regulations, and with that come pretty stringent enforcement policies. But if you look at Denmark and France, the issue to a business is the fact that in France, if you find that there's an issue for data privacy, the regulators will actually come into your firm and they'll find out which part of your processing is actually at breach, and they'll close that processing unit down. Now, in Denmark, they take a different approach. They're not that fussed about what part of your organization is actually breaching data privacy. They'll just close you down. So they'll actually strike you off the corporate register if they feel that there's been any breach in data privacy. UK, mainly, it's a fine. They're not as draconian as Denmark. And in Canada, that's quite a headline figure. So this is with regards to the anti-spam legislation, so 10 million Canadian dollars. So I think what this presentation has served to do is to highlight some of the data privacy regulations, highlight some of the issues that a company faces, especially with some of these new issues such as employee blogging, also provide an insight into what the penalties are. And I think it's a summary of actions for a corporation. I think you should consider keeping abreast of those local regulations. I think you need to check your employee agreements and check your corporate contracts to make sure that there's clauses in there to protect you. Review your policies and communications internally as well, and look at what internal controls you have. And with that, that concludes my presentation. So I know that we're running a little bit behind time, and I know you're probably very hungry as well, but if there's any questions that you've got with regards to this particular topic, then obviously do fire away.
Don't ever want to speak at once.
Thanks for your time.
Okay, thank you very much, Stuart. Appreciate it.